Fantastic. Charles, Charles, could you give me access to host,
Yep.
please?
Okay, you should get it.
Okay. Yep, it's working. All right. Can you guys see that screen, the PowerPoint screen?
Yeah.
All right. So let's get started. There we go. All right. Hi, guys. Good afternoon. My name is Ben Mirza. Today, we're going to be talking about assessing liability risk and how to protect your professional practice and reputation. This is a topic that came about because as Charles was speaking with different individuals, I think he actually saw a need there for people to understand how their licensure, how their reputation can be affected in the healthcare sector. So as requested, here's the actual seminar. Today, I mean, just to actually start off with a quick little story. There was an individual, a healthcare provider, that called me not too long ago, and the reason for it was because she received a complaint from the Department of Health. That Department of Health was looking to take away her license, and had not only sent her the complaint, but also attached to the back of it forms that she could voluntarily give up her license. And then she calls me up and says, "Hey, what do I do about this?" And I looked at it and I said, "What happened?" And she said that she actually had a hit and run. So basically the other person took off. And then when they took off, she also left. So that hit and run, the other person ended up calling up the cops. The sheriff recorded it as something that she did, and that went to court. She got prosecuted on it in court and was found guilty of it. And then what happened is that she ended up that the Department of Health ended up finding out about that conviction, and then sent her notices to revoke her license because she failed to report. So, something that you may think is not related to your license, something like that, like a driving incident, can actually impact your license. And it's because there's a professional responsibility behind it. Now, Ed's got a pretty interesting example regarding medical staff.
Yeah. I mean, I had an executive, actually was a medical executive years ago, who was hired. And then someone else on the staff came up to me and said, "Have you pulled up this person's name on Google?" So he Googled the person's name, and first thing up was her picture, her mugshot from a DUI. Because there's companies that'll take DUI mugshots and put them on the internet and then have you pay to get it off. Fortunately, this individual had fully disclosed to the hiring folks that this was something in her background, explained it, and so that did not affect at all her hiring. But it is something out there that she would always have to explain to individuals about her background, because you pull up her name and it's right there, her nice picture of her mugshot and the conviction on DUI. So these things are out there. The bottom line is make sure you're disclosing, and
Today's
don't avoid disclosure.
So today's seminar is really intended for physicians and anyone who's on the medical executive committee, in-house general counsels, and even administrators, because they've got to be attuned to what affects people's licenses. This is a presentation that's intended only for informational and educational purposes. This is not legal advice, so just be forewarned, as we talk about scenarios and situations, they are literally educational and informational.
And as Charles noted, that this is being recorded. So keep in
So,
mind.
yeah, so this is being recorded. So just if you don't want to be recorded, you may just want to go in the dark on the dark on that one. But we appreciate and welcome your presence. We would like to have you be on viewable if possible. With that said, just to give you a brief introduction, my name is Ben Mirza. I have been an attorney for over 20 years. In my former life, I was a CPA, an accountant. I did work over at FPL Group, that is. I've been inside large organizations, small organizations, large law firms, small law firms. And as of about 2 years ago, we decided to take Mirza Healthcare Law Partners as our firm, and we launched it. So although I've been involved in the healthcare sector for a fairly long amount of time, our law firm is relatively on the new side. Um, I've litigated well over 2,000 cases. I've negotiated, probably into the billions of dollars of contracts, as well as reviewed easily thousands and thousands. So that's my background. It's pretty far and wide and varied. Um, but the person that I think is really the guest of honor here among us three is Ed. Ed Meyer brings with him a very special background. It's exclusively in healthcare, and it started, and his career started in the 1980s. Ed, you want to?
Yeah. So yeah, again, thank you, Ben. I thought you were going to say Charles, but this is Charles' presentation.
Oh,
So, yeah, I'm Ed Meyer. I am of counsel to Healthcare Law Partners. I am an attorney licensed in California, not licensed in Florida. So I don't handle Florida specific matters. Ben, I do anything through Ben on that, other than handling federal matters. I am on my 30th year of practicing healthcare law, and most recently I was with Mednax. They're out of Sunrise, Florida, in their Texas office, handling the Midwest. But my background, I've dealt with representing large national medical groups, individual small groups, physician groups, individual physicians in various matters, regulatory compliance matters, peer review matters, and also having been on the hospital side, working for some of the largest health systems in the country. But before I was even a healthcare lawyer, I worked at the U.S. Department of Health and Human Services as an appointee in the Reagan administration, and before that worked for a member of the House Ways and Means Committee on many of the laws that were passed that we deal with today. But I'm very excited actually to have Komal Mirza on with us. She is an ace litigator, and so Komal, why don't you introduce yourself?
Thank you for the generous introduction, Ed. My name is Komal Mirza. I happen to be Ben's niece, but I consider myself Ed's junior. He does have 25 years on me with healthcare law experience, but I too once worked with a member of the powerful Ways and Means Committee, and was actually at the table when the Affordable Care Act was being negotiated. Currently, my primary practice area is in representing physicians, assisting them in establishing their practice groups, navigating their employment contracts, the non-compete clauses specifically. And today's presentation should be interesting in the sense of it'll show you, give you some pointers on how to establish your office culture and maintain your reputation while also minimizing your risk of liability. So with that, I'd like to turn it back over to Ben.
So we start all of our seminars essentially with market forces that are affecting the topic that we're going to talk about today. So starting from the bottom, the change of technology is pulling physicians in multiple directions. Their processes are changing, and so as that changes, their requirements are also changing. Their standards of care are changing. So their regulatory issues are also affected because conditions of participation require the physicians to hold up a certain standard, and all of this is affected by their license that may be under fire for medical malpractice sort of lawsuits or professional licensing complaints. It affects the way they are rewarded financially and reputationally. So the market forces here are great. They're significant. They're not to be looked at lightly. If you look at a physician that produces a certain amount of revenue a year, and if they produce based on their license, let's say that under their license, they're billing out at about $2 million a year. over just a 10-year lifespan, that's a $20 million
So just
revenue
close the
producing.
door.
So as their revenue producing for 20 years, you know, how much time and effort do you spend protecting your license? So, you know, what you have to do is you really have to approach it with a team that's got diversity of thought and discipline. And that's what I think we bring to the table here. So let's get started. Today's seminar is intended to be for about 50 minutes. And the good news is we're already done through about 10 minutes of it. So we're going to touch on several things. We're going to talk about the patient setting and how that can affect your reputation, the office setting and how that can affect your reputation, the hospital setting and how that can affect your reputation. And last but not least, we're also going to talk about defamation lawsuits, because that is something you need to be aware of in case if things do go down that road. So with that, let's get started. And starting off with actually reputation, we're gonna talk about patients. And you know, patients, they essentially have two avenues. One is licensure, right? So they can actually go after a physician's license, or they can sue them for professional liability, right? In office situations or office settings, there's primarily HR or HR policies or corporate policies and procedures that are in place that one has to be mindful of. In a hospital setting, it becomes even more complex. In a hospital setting, you have HR policies and you have the medical executive committee and the hospital bylaws and the medical staff bylaws and so forth. And then there's also a possibility for the executive action to do some enforcement. Last but not least, we're also going to touch on in this seminar on regarding online reputation and how to manage that and what you can do about it if there is some sort of a negative remark in on Google or any of the other reporting medias that you get a negative remark on.
Yeah, so again, you know, we want to stress, go back to the last slide. Keep in mind is, you know, you may feel like, you know, you focus on patients, you're spending patients with every day, and you know how to protect your, let's say, you know, protect your reputation vis-a-vis that patient interaction. But keep in mind, you're also working in your office. In your office, you're working with staff, you're working with other physicians. You also have your referring physicians. All those have potential reputation issues. And then once you walk into the hospital, there are reputational issues that you need to always be mindful of, because you may feel, let's say, comfort level with the patients, comfort level in how you handle your office, but that hospital, once you're in the hospital is like a machine, because they have a much higher risk because they're a large entity, they're a deep pocket. And so on reputation issues, they have to go through, when something hits them, they have to go through their formal processes that may be out of the physician's control. So it just means it's real important to be very mindful once of those aspects, which we'll talk about in a moment, of the hospital and how they can affect your reputation and how to kind of maneuver through them.
Thanks, Ed. Yeah, so let's talk about the patient setting, right? So in a patient setting, a patient can obviously file a complaint. And if the complaint is essentially states out merit, you know, the plain allegations with sufficient facts that are worthy of investigation, then the Department of Health will start an investigation. They will inquire about the actual records. They will talk to witnesses. They will subpoena records. You know, just like we had mentioned earlier, there's actually very specific Florida statutes that talk about what is or is not a reportable issue. Do keep in mind that even a no contest or nolo contendere conviction or admission to a crime is a reportable offense. So be mindful of that. The other thing that you should be also mindful of is that if there's any sort of disciplinary action taken at a hospital or by an HMO or by an ASC, an ambulatory surgical center, regarding privileges or decrease of privileges based on a professional quality issue, it is a reportable issue back to the state. So, you know, a lot of these are mandated in statute. you really want to be mindful of where you're headed with the license, what things can affect it. Even so much so, the Florida statutes even say that if you've actually diagnosed, if you've actually worked on an area, like for example, the wrong foot surgery, or if there's been a wrong amount of medication for the wrong patient, if things like that, incidents happen, they're considered more significant failures. Those are all reportable events, and the Florida statute requires those to be reported. So do keep that in mind. Those are your licensing complaints, and that's pretty much where they'll start from. Anything else you guys want to add to this?
Yeah, I guess what I mentioned too is, keep in mind, okay, a patient has a complaint. Where can they complain to? They can complain to the physician or the practice. The practice could, address it. Or a practice could potentially ignore it. And then they go and say, I'm going to go complain to, let's say, a lawyer, or I'm going to write a letter first. I'll write a letter to the licensing board. Or I don't get enough response, they go to a lawyer and file a lawsuit. Or they could, like I had a case where a patient complained to the Office of Civil Rights in Washington, D.C., because this particular physician patient came in for some foot surgery and disclosed to the physician, they just want to know I'm HIV positive. And the physician said, no, I don't treat HIV positive patients, which is an immediate, discriminatory action. And the patient complained to the Office of Civil Rights, and the Office of Civil Rights came in and started investigating it. They investigate the physician, they investigate the employer, they investigate the practice setting, all of which affects the reputation. So it's just so important at the very, very beginning of that interaction with the patient is to know that things can bloom out pretty much out of control fairly quickly if it's not quickly sort of addressed with the patient, if that's possible.
Good point, especially the OCR. Ed, that's a good point, because people don't think very often of the federal statutes and how their license can be affected. So continuing down the same road, the other option, as Ed had just touched on, is malpractice lawsuit. So what happens if there's a malpractice lawsuit, right? So for what are you going to do? I think the first thing that you're going to do is you're going to contact your insurance carrier. And then through the insurance carrier, you will generally hire a legal counsel. And that legal counsel is then retained to actually defend you. And along with it, typically your employer, meaning the company. Now, do remember, the insurance carrier is paid by your employer. Their primary concern, the attorney that's hired by the insurance carrier, their primary concern is to make the insurance carrier happy, which in turn is to make your employer happy, and not necessarily to make the physician happy. So the interest of the physician is minimized, right? So you got to be careful of that. If you do have a particular issue regarding malpractice lawsuits and your case has been sitting out there, I suggest that you just call us. We'll give you as much of a free consult as possible and give you some guidance as to what needs to be done. It's not a problem. No skin off our back. We're actually happy to help you. But that's something you do have to look out for, because if your name is stuck in that final settlement agreement, you are deemed to have settled the case. It's very important in a malpractice lawsuit that your name does not show up on the final judgment, and it does not show up on the actual settlement agreement. Otherwise, you are deemed to have settled it yourself. And when that happens, that's again a reportable issue with the NPDB, which is the National Practitioner Data Bank. So be careful of that when you're dealing with malpractice lawsuits. Call us if we can help you. Now, as malpractice lawsuits continue on, there's usually a subpoena. They can actually subpoena your colleagues, your staff, your nurses. As long as there's a connection to the litigation that's related to that patient, they can actually subpoena those records and staff. So be expecting that. The other thing is, there are ways to actually minimize or avoid these disputes, or by taking it out of court. And there are alternative dispute resolution possibilities, meaning like you can go to the AAA, which is the American Arbitration Association, and there's several other associations which we'll often do on behalf of our clients. We'll try to get the opposing side to take it off public purview and put it into a private arbitration mediation sort of a setting, so that all of this stuff is not laundered out on the streets. It's actually done internally as
Yeah.
much as possible, as much as you can protect it.
Similarly, when contracting with the hospital, say for a coverage agreement, or any sort of contract with the hospital, there's always that alternative dispute resolution provision, and to consider whether or not to include an arbitration provision in there, which again keeps that a dispute that a physician might have with the hospital that could affect their reputation, keeps it effectively out of the public domain because it's done via an arbitration. And that arbitration then is private. It's not going to court. Other than sometimes there may be a provision that says in those arbitration provisions to be careful about, that allows at the end of the day, when that arbitration is complete and final decision and settlement or whatever is in there, that one party may actually file that settlement with the court. So all of a sudden the final action may be on that dispute may be public. So just those are little things to be very careful about in
That's a good
protecting
point,
one's
yeah.
reputation. Yeah.
So,
So moving on.
it's almost like-
that's you, Como.
I've got it. So being a millennial, of course, online resources and online reviewing is very important to a growing majority of patients these days. 84% of patients now research new providers before their first appointment. 37% of patients use online reviews as a first step for a doctor's search. And 61% of patients have actually said that they've avoided doctors based on negative reviews. So why is this important? Obviously, because your online reputation has a direct impact on your patient inflow, on the amount of new patients that you're receiving. The best way to kind of avoid that negative impact potential of negative reviews is to monitor your online reputation. There's a whole list actually that we provide on the next slide of sites that you can actually go to and stay up to date on your most recent reviews. One of which, and the first and foremost that I would recommend, is probably Google, because when somebody hears of it, I can tell you, attest to it myself, when a friend of mine or somebody I know recommends that I go to a particular doctor, I'm Googling that doctor. I'm looking at the reviews that are coming up. And so, you really want to keep an eye on your Google reviews. You can take a look at at Vitals. You can take a look at Health Grades, ZocDoc, CareDash. All of these websites maintain profiles on almost all practitioners, at least. Usually they reference the Board of Medicine or the Department of Health's licensing lists, and that's how they create the profiles. So you can actually go ahead and log on to, for example, ZocDoc, and claim your profile and keep an eye out on the kinds of reviews that are being left by former patients. Sometimes even employees will leave reviews. And so it's a great resource and a great way for you to keep an eye on that. And then in the event that you do see a negative review, on the next slide, we've actually got a step-by-step suggestion of what you can do in response to a negative review. You want to address it as soon as possible. And you want to address it with humility. You want to make sure that in your response, you're not providing any confirmation of any sort that the reviewer was in fact a patient. You don't want to disclose any information that would be protected by HIPAA, because one key point to remember is that even though a former patient may have left you a review online, they have not consented to that information actually becoming public. And so there's a very fine line that you have to kind of toe when you're responding to these negative reviews. Basically, the basic response that a lot of these sites recommend, and even I recommend, is just to say, thank you for your review. Other reviewers may have a different viewpoint or have expressed a different viewpoint. And just leave it at a very generic, very professional kind of a response.
So if you take a look at this practice pointer towards the bottom there, that's where actually what Como is talking about is to be empathetic, to state what your goal is. So a typical sort of a response to a negative review would be something like, we are sorry to learn that, whatever they thought, which was a negative thing, right? And that it did not live up to your expectation. Our goal is to always, maximize, provide access, whatever whatever our goal is pertaining to what they saw go wrong, and then thank them for their time. And then also tell them that we'd love to make it right. And we would appreciate it if you contacted us and gave us the opportunity to make it right. So those are very generic statements. And you're only talking about as to what they say. And you can always talk about your own aspirations and tell them to contact you. And I think that that's a nice way to manage those negative reviews. And it'll help you actually gain more credibility with any new patients.
It also shows too that you're actually paying attention to people's comments.
Yeah,
I mean,
true.
if you have all these negative reviews on a site and you never looked at it, someone's going to see that and go, oh, they must be really bad. But if you're seeing a response, if the viewers are seeing the response, they're going, oh, obviously you take your reputation seriously and you are
If
responding to
online
it.
reviews are important to you, you may just want to take a snapshot of this particular slide and the next one. So I'll give you guys just a few seconds. You might want to pull out your camera and just take a picture of it. And in another
It is
couple of
also-
seconds, I'll switch it over to the other one. What were you going to say, Como?
I was going to say, a lot of these sites also, like, for example, when you claim your profile with ZocDoc, they allow or give profile holders the ability to refute negative reviews. Say, for example, a former patient leaves a false review or an inaccurate review. You can actually go ahead and bring that up to ZocDoc, and they'll review it with you and ask you for confirmation as to some sort of confirmation as to the falsification of that particular review, and they'll actually go ahead and take it down if it pans out in your favor. So, that's another good mitigation to keep in mind.
These website marketers, they're really good at that sort of stuff, especially the experienced. They're pretty good at it. That's their forte. But this is a typical sort of a response. And then also on this particular slide, how Como had actually laid out what you can do. This is all a part of that, and it goes in with that other paragraph we just showed you on the last slide.
Yeah.
So okay, moving on. I'm going to take you to the next setting. The next setting is the office setting. And Ed, you want to leave this slide?
Yeah. Again, when you're in your office, you got to realize, you're not just dealing with patients, you're dealing with your staff. You're dealing with your professional staff. You're dealing with your other, just your regular staff, the front office staff. You're dealing with other physicians and your referral sources. How you address your reputation can obviously affect your business. If you have a healthy work environment, you have a cohesive team, you have clear office policies, you may reduce your staff turnover because people are happy with where they work. If, however, you have a office situation where the physician is considered, and keeping in mind, we understand completely, there's significant pressures on the physicians. Communicate those pressures to the staff so that they understand, the importance of the physicians to be able to focus. But sometimes when that's not communicated, the staff may, see this and feel negative impact on how they feel at work. And you never want to get to the situation where staff feel that this is not a good place to work, because one, not just turnover, but you also can always feel that there's a potential for a whistleblower action if the staff feel that they have a major grievance that's not being addressed. So that's a very big issue for risk to this.
And the other thing is, when it actually comes to whistleblower actions, it's usually those disgruntled employees that actually raise whistleblower claims. That's where a majority of the cases come
Yeah.
from. That's why they even suggest that, you should really do an exit interview on all leaving employees, because usually if a whistleblower action is coming, it's going to come after the person leaves. So what you want to do is you want to give the actual departing employee the opportunity to vent and discuss with you what they thought was good and what could use improvement. So these office settings are important. They can really impact you in multiple ways. Reputation matters. And the best way to do it, like Ed said, is to actually have a healthy work environment.
And keep in mind, obviously staff have, employment law rights. Staff could, have rights not to work in a hostile work environment, not to be, abused. And they can actually go to a litigator and say, look, I work in a hostile work environment, and sue the company. So you just got to be very careful with your staff. And I know that sometimes in smaller office settings, for sometimes I've seen some of the physicians may go, well, hey, there's a lot of joking around. Everything's okay. We could joke around. Everyone gets it. And maybe everyone does get it, but that's them getting it. Keep in mind is once you go to this next slide, you walk into the hospital, and what you may think is okay to occur in your staff, it may not be okay to occur in the hospital. I recall one instance where I had a physician who, with his tech, would joke around a lot, would joke around and make, grossly inappropriate jokes. And that technician thought they were funny, and they were just between the two of them. But one day in the hospital setting, they say this obscene joke to each other, and who's walking by but brand new employees of the hospital. And that hospital, those people overhear it, and they go right to the hospital executive and say, I can't believe I just heard in my office in the hospital. I just heard these people say this thing. And the hospital, which has significant risk from not having a hostile work environment in the hospital, is at risk. So they obviously switch into their mode of protection, and go into get the next slide, go into their mode of protection and start dealing with their services and their processes and their policies, their HR policies and whatnot. So again, keeping in mind on the hospital side, you have a whole slew of processes and that address issues that can affect your reputation. So on the HR side, you have corporate policies and procedures that they must follow. You have the hospital bylaws, you have the medical staff bylaws, all of which affect your license and your ability to work within the hospital setting. If there's a behavior issue or a professional competence issue, those all can flow into these processes. So a hospital may see a behavioral complaint. Let's say the physician said something obscene, or the physician got mad because they're under a lot of stress. We understand that, and threw something at someone or towards someone, or acted inappropriately with, they didn't think it was inappropriate, but the person perceived it as inappropriate. Those then go into the whole process of the HR folks looking at it and investigating it, and then it can even raise into potential MEC issues. Keeping in mind this, I just want to point out this number 5. If you're a physician with a hospital contract, especially say you have a closed department and you're in the group that's in the closed department, many of those contracts have provisions in them that provide the hospital executive to say, well, this person's still on the staff, but they're not providing services under this closed contract. I refuse to have them here. And circumventing the due process rights that physicians may have. So that's something very important to understand, whether that's in your hospital contract or not. Again, your reputation in the hospital is important. The key thing that I've always seen, though, is for physicians, is usually issues with physicians have a different levels of how they're addressed. So usually it's they take another physician on the staff, go talk to that physician we have a complaint about. They talk to them, say, look, what's going on, et cetera. The physician may ignore that. And if they ignore that, not take it seriously, then it's going to the next level and then the next level, and it may end up being an investigation. So just be keeping your reputation intact is be very mindful of when you're receiving criticism from your colleagues and take that criticism to heart. And realistically, if a physician does, have I say anger issue, there's a lot of places to go to assist in dealing with that anger issue, so that the hospital sees you addressing that and they're going, okay, because physicians are hard to come by, realistically, from the hospital's point of view. But the hospital does not want to have that risk. There's lawsuits. I remember there was one lawsuit where the physicians had a hospital where saying inappropriate things in front of the nurses in surgery. The nurse complained to the hospital. Hospital president completely ignored it, and the nurse sued for hostile work environment. And that jury, like I always say, when you go into a jury, I used to work at a Catholic system, so we say, WWJD, tell the doctor that. What does that really mean? What would a jury do? The jury is not going to care about the physicians, being a big referral source to the hospital. The jury is made up of individuals who, stay-at-home folks, maybe have a very low income, and they're going to look at this very, very carefully. That hospital, particular incident I'm talking about, ended up being, I think, a $400 million jury verdict on a hostile work environment matter. And the hospital president lost his job, et cetera. But just take these matters at the very beginning seriously, to protect your reputation. That's really the bottom line. A lot of this stuff, when you see a potential issue, address it. Anyone add there?
Yeah. I just want to touch back on the MEC actions, right? So,
Ben,
so the medical,
I got a quick question.
Sure.
What happens if, and a lot, I'm not sure the physicians that are on here tonight, I know maybe a small office where they may have 1 to 2 people that are their employees within the office. How is the liability for the physician affect their, I guess, reputation would be one, the licensure for an employee that works for you? So an employee does something, can that affect their licensure?
yeah, because
Your
ultimately,
supervisor.
Ed just said it. Essentially, the physician is deemed the captain of the ship. Everybody that works under the captain of the ship, the captain is ultimately responsible for. So whatever a employee does, so like for example, if you have a medicine cabinet and there's medicines missing from that cabinet, and you fail to supervise the cabinet, even though you had nothing to do with taking any of the drugs or losing any of the drugs, if there's actually drugs missing, that's going to be held against the physician.
Yeah, because on the drug part, especially the DEA, to actually have controlled substance in the office, let's say testosterone, that's a Schedule C, Schedule 2, I think, drug, pharmaceutical. So that's controlled by the DEA, and for that to be held in that clinic, the physician himself has to certify that the processes are followed. So that if the processes aren't followed for securing those pharmaceuticals, even though the physician had nothing to do how those pharmaceuticals went missing, then that's on the physician. Similarly, even if the physician may be owners of the practice itself could be sued. So, and
the medical directors really get hung out to dry in this, because they usually have the ultimate responsibility for managing that group and the people that are in it. So the medical directors, whoever's license is on the line, for that clinic, for that facility, they can get taken to the mat on that one. And so anyway, so what I was going to, does that answer your question, Charles?
Yes, it does. Yes, it does. Thank you, Ben.
Okay. So then the other thing that I did want to touch on, and Ed talked about this, is the medical executive committee, right? So the way things rise to the medical executive committee is two ways. One is either by special incident or which causes an investigation to take place, or the other is a regular and periodic review and analysis of things that have been occurring. And so under either of those circumstances, a physician can come under review, and depending on what they find and the professional standards for competence, whether those are being violated or breached or not being followed, that's really what's going to put the physician in a lot of heat. So keep that in mind. When that does happen, you do want to involve somebody in your team, somebody who you do want to consult with other physicians, and you do want to bring on board an attorney, because I think that there's ways to say things, and then there's other ways to say things, and you want to make sure that you've got somebody on your team that's going to help you get there. And not only that, but I think it actually shows a much stronger front to the other side, so you don't get railroaded into a peer review that's just pretty much angled against you, and now you're going to have a hard.
And keep in mind, with peer review, the physicians, as per the bylaws, have due process rights. So the hospital has to follow those due process rights when that formal peer review occurs, except if you have that contract with the hospital, and that contract has that provision in there where the hospital executive could say, this is a closed staff, I don't want that person providing services under this contract. Now, they're still on the medical staff, but if they're of a specialty that could only be working within that closed staff, they really can't be working. And sometimes the hospital's interest, oftentimes, it could very well be in the hospital's interest, I should say, to avoid a lengthy peer review action by looking at that and doing that action. Now, what I've always said, I've always tried to, in those contracts, to add due process provisions to them, or at the very least, if they're there without them, if the hospital president is saying, I don't want that person there, you all want to push that hospital president and say, I want to see that in writing. It's not an oral statement. If you're exercising that contract right, I want it in writing. They can put it in writing that they don't want it there, which then may give that physician potentially a potential cause against the hospital to try to protect the physician.
All right. All of this actually has to do with the communication culture a provider brings, right? So there are several things here. You've got to really figure out how you intend to communicate with staff amongst themselves, how the staff is going to communicate with upper management. Como, do you want to touch on any of this stuff?
Sure. I mean, some of the more important, one of the biggest things I think a lot of physicians kind of miss or forget to think about is really who is going to be speaking to your patients regarding concerns. What, how does that concern get handled? If it needs to be escalated, when does it get escalated, and who does it get escalated to? And then at the back end, you also want to pay attention to whether that concern that was brought up by the patient can be avoided in the future, and how you can avoid it in the future. These are all things that kind of minimize the frustration that a patient may feel. And it also minimizes the amount of frustration that your staff feels, because they know exactly where to go, when to go there, and who to go to for help regarding a patient. You want to embrace any kind of criticism that may come your way, whether it's from staff or your colleagues or from your patients. What that really does is that it gives you a moment to think about what those concerns are, where you have room for improvement in your practice, and it ultimately helps you avoid any kind of risk of liability. It really does minimize that risk for you. These are all really important things to kind of keep in mind. And at the end of the day, it also has an impact on your quality healthcare indicators. When a patient turns around and leaves a review that, or completes a survey, there's an impact. So all of these little things that seem like they're tedious or just too minor to like minor things that you can deal with later, they eventually snowball, right? So if you create a culture of communication, and embrace criticism from the onset of your practice, you can really help avoid liability and risks.
Yeah, and also keeping in mind that, these quality indicators, physicians are being surveyed, patients are being surveyed, and part of many of those survey results are part of incentive compensation that might be in, a payer's contract or maybe in a hospital contract, meaning, certain, patient satisfaction survey results or satisfaction results by your colleagues and professional reputation. So all those are come into play, and which is so important in making sure that communication and how you deal with folks, it really not just reduces your risk on a negative reputation, but also enhances a positive reputation and it can enhance income.
All right, so now, last but not least, we're going to talk about defamation a bit, because I think when you think about reputation, defamation is definitely a part of it. And as a lay person, what you really need to consider is that there's two different types of defamations that take place. One is libel and one is slander. Just remember, slander is spoken, libel is written. So when it comes to these sorts of statements, they have to be, number one, it has to be a false statement. It has to be said by the actual defendant, the person that is being accused of making those false statements, and it has to be made to a third party. So like somebody else has to hear it. It's not just a two-way communication going back and forth. It's actually to a third party on the outside. And last but not least, it's gotta cause some kind of damage, right? And damage is always calculated in finance, right? In money. So how do you prove that something has caused a particular damage? And the only way you can really do that is if a particular contract then immediately is brought to an end because of that defamation issue, or if there is a loss of revenues that you can directly attribute it to that particular statement. That's how you actually establish damages. And for that, you're going to end up hiring somebody to actually help you assess that. But that's always a part of it, and that's also the hurdle that a lot of people have to get over in order to have a successful defamation lawsuit. The typical defenses to these lawsuits are, number one, is no damages. A lot of times there can be negative statements made, whether it's in writing or spoken, but it's really hard to prove the damages. So that is what I found is the most common defense. And there's other defenses. There's actually a whole slew of about a dozen defenses. The other one is actually truth in fact, that something was in fact true, even though it was negative, right? So how do you argue if somebody's accuracy on something is 70% versus where it should be is like 80% or higher, whatever that is, that threshold. If you're actually arguing statistics and you have an actual statistic to go support that statement, that's called a truth in fact. And if it's a truth in fact, that's a pretty nice defense to have. And last but not least, there's also what's deemed a pure opinion, because everybody does have a right to their opinion, but the opinion can't just be disguised in like a bunch of facts and then you throw in an opinion in the middle of it. It has to be said in the context that's evaluated holistically by the court. So pure opinion is another defense, but it's got to be said in that opinion sort of a setting and not just buried in the middle of facts. When it comes to actually being defamed, there's actually two steps to it. Number one, you can actually send over a cease and desist letter to the other side and tell them, hey, you're doing this, please stop. And if they don't stop, then you actually have a cause for a cause of action or a lawsuit, and you can file a lawsuit. But your first threshold is going to be, what are your damages before you file a lawsuit? Now, cease and desist letters, they do work oftentimes. People will stop if they're on the edge of writing something, saying something improperly. But usually it requires the retaining of legal counsel that's going to send over that threat to the other side to say, hey, we're taking this issue seriously. You need to listen up and stop talking about it in that negative way because it's uncalled for. So that's our defamation. Anyone have any questions at this stage? Anything you want us to go back and touch on again? Because we are at the end of our presentation.